Performance and breach. When a party fulfills his contract, then his obligations are performed. If he fails to perform, then the other side will have a right to demand an appropriate contractual remedy. The important goal in remedies is the fulfillment of reasonable expectations. So let's talk about conditions. Some contracts will have conditions. There are condition precedents, which is a required state in the creating of a present obligation to perform. So for instance, in a sales contract for the sale of a house, there's a condition precedent that the house, the owner of the house allows the buyer to perform an inspection of the house and that it pass inspections. So it has to pass the inspection. This is in almost all contracts for purchase of a house. If you know what you're doing, you're going to have it inspected, and it's going to be in the contract that you have a right to demand that inspection, and you don't have to go through with the contract until the inspection comes back and it is satisfied that the house is in good condition, which is also standard in most contracts. So if there's something wrong with the house, it has to be fixed before there's an obligation to go through with the buying of the house, to give them the money for the house. For them to get the money, they have to satisfy the obligation of having the house in good condition, and that is got to be certified by the inspection. So that's a condition precedent. There are also condition subsequents that will terminate an obligation to perform in some contracts. There are also condition concurrents, which are obligations that occur on both sides. So for instance, if you were to do some work and I am to pay you at the same time, that would be condition current. Conditions can be either express or implied conditions. Express conditions are found in the contract. Implied conditions are supplied by law. We're not going to go into conditions deeper than that. Discharge. By performance in most cases is what is going to be discharged. When a party performs, his obligations are discharged. Substantial performance may in some cases be enough. Substantial performance occurs when the exact performance isn't maybe actually made, but the court determines that something equivalent to what was the exact performance is all that is necessary to fulfill the reasonable expectations of a party. And so in one case it involved a sale of a house, and the builder in the house had substituted the modern plastic plumbing for the old metal plumbing of copper. So he used the current kind of pipes that they use in there, and the contract called for copper. At that time it was new, and the buyer was very disappointed when he realized that there were not copper pipes in his building, and so he was refusing to pay until the contractor had removed all the plastic pipes and put in the copper pipes. So the court found that the new plastic pipes were as good as, or even maybe perhaps better than the old copper pipes, and therefore he didn't have anything to complain of because there had been substantial performance. So sometimes substantial performance is enough, so it's arguable whether or not something is or is not substantial performance. By agreement. One way the parties can be discharged is by agreement. They can both agree to rescind. Now if you're in a contract, you have both entered into the contract and both of you are obligated to one another. Therefore, in order to discharge it by rescission, there has to be agreement of the parties. So both parties have to agree to rescind. One party cannot rescind without the other party agreeing to it. Novation is the substitution of a party. So another party comes in and takes the place of the party who was originally contracted. You might have that, say, if you had an electrician and he was unable to perform, but he contacted some friend of his who he vouched for as being a good electrician, and then you allow this other electrician to take over for his friend who couldn't for some reason perform, perhaps for sickness or some other reason. That would be a novation. Substituted agreements also occur where you substitute a new agreement. So the current agreement isn't working out. One of the parties may be seeking some sort of accommodation And you substitute a new agreement. Oftentimes that's not necessary. Oftentimes you can just simply amend the current agreement, and that's fine. What's important in all these cases is that both parties agree to the new agreement. Both parties agree to the new party, the new person taking over, to the novation. Both parties have to rescind. Okay. So an accord and satisfaction happens when one of the parties, agrees to be satisfied with something less than what was promised, and so that would be an accord and satisfaction. If he signs off on it, and the other party agrees with that, then that's the end of the issue. So there's a discharge there and an accord and satisfaction. By operation of law, sometimes there's a discharge. If one of the parties unilaterally alters the contract, that would discharge the contract. So, one of the parties could not mess with the contract without the other party agreeing to that. So the contract can be changed, but only by both parties agreeing. Statute of limitations. Sometimes the contract runs out because of statute of limitation. Very rarely does this happen because the statutes of limitations for contracts is usually fairly long, 4 years and sometimes even longer, depending upon the kind of contract it is. Bankruptcy. There's a discharge in bankruptcy of a debt. Debts are oftentimes contractual obligations that a party has. And in bankruptcy, the judge at the final hearing will issue a discharge, discharging the debtor of all debts except for those that have been reaffirmed. So some of them might be reaffirmed. Things like the mortgages, which are long-term commitments. It doesn't do any good to force the bankrupt to sell his house because the money is all going to go to the bank. As long as he's able to make payments to the bank is satisfied, doesn't want that to happen. And the other creditors are not going to get any benefit from forcing a sale of the house. Oftentimes the same sort of reasoning is applied to automobiles. We're taking the person's automobile. He only has one automobile. He's using that to work. He's therefore being able to make payments from that. Oftentimes that's not going to really substantially provide enough equity for others. Oftentimes it's simply a matter of the car dealer from which he bought is going to get the money if they force the sale of the car. So bankruptcy results in a discharge of all debts except those that have been reaffirmed, and the court has to do those reaffirmations. And all other debts are discharged. Impossibility. If it becomes impossible to perform a contract, it's not unusual that something is impossible, but if something becomes impossible, then it might be some physical reason, storms, or storms could maybe interrupt the shipment of goods so that the contract for delivery of goods cannot be made on time. It might become impossible to perform the contract. That would be a good reason to discharge a contract, and there's no breach of contract in that impossibility. The party who agreed to do something that later became impossible, as long as it's not foreseeable at the time that it was impossible, you can get out of it. Also, impracticability of performance is sometimes playing a role, which is something less than impossible, but is substantial nonetheless in terms of making it difficult to perform. Anticipatory repudiation. This most often is a clear indication that one party will not fulfill his contractual obligation, which will give the opposing party a right to treat the contract as having been breached. However, until the non-breaching party has reacted to the repudiation, the breaching party can retract his anticipatory repudiation. More later on anticipatory repudiation. It sometimes can be invoked where the one of the parties is insecure because he thinks the other side may be going to breach and wants to be reassured that the other side will perform. So we'll talk more about that later. Limitations on remedies. So there are various limitations that come into effect when we talk about the performance. In the absence of bad faith, there is no right to punitive damages. Contractual terms may establish the damages, but not if they are unreasonable in light of an anticipated harm. So a lot of times you know that some things happen. For instance, if you own a theater, you know that on occasion some performer might not be able to come and perform as was agreed. In that case, you'll usually put into his contract an agreement that if he doesn't come, he will pay a certain amount of damages. Several reasons for that. One reason is that you cannot order somebody to come and work for money because that's against the law. It's akin to slavery. Bonded indentured was outlawed in 1898, I think. Anyway, so you would have this agreement in there, and so the performing party, say he's Elvis Presley, say he's any performer, whichever performer it is, would have to pay the agreed upon amount of damages. As long as they are reasonable in light of the anticipated harm, they're okay. How do you determine what's reasonable in light of the anticipated harm? Well, you have to have expert testimony, typically, of people who would have studied the effects of a cancellation on crowds like that. Anyway, so that's a limitation on that remedy. Specific performance is only available in cases where monetary damages are inadequate and are not available if they would result in involuntary servitude. So we mentioned that before. You cannot force somebody to come and perform because it's involuntary servitude and it's against the law. Also, you have to show that monetary damages are inadequate. So for instance, certain items are unique or rare. For instance, if you had a contract to buy somebody's rare Vincent van Gogh painting, that's only one of the, I mean, there's very few Van Gogh paintings, there's only one like that, and therefore it's one of a kind, and therefore monetary damages are inadequate. There's no market for it because that market is just simply, it's put up on auction, right, and it's bid. It's oftentimes bid up. So you can talk about that being a market, but it's not like you can consult the market for what the price should be that should be paid for damages. As we'll look at it later in terms of how you determine damages. Contractual terms may establish the damages, but not if they are unreasonable in light of the anticipated harms. We talked about that already. Mitigation of damages. A party has a duty to avoid, whenever reasonable, the consequences of the other side's breach of contract. And so that means that he may need to make adjustments, so he'll need to maybe come in and fix things. So you got to keep the damages down to mitigate the damages. Also called the avoidable consequence rule. Commercial impracticability. In the sale of goods, a failure to deliver goods is not a breach when performance has been made impracticable by the occurrence of a contingency, the non-occurrence of which was a basic assumption on which the contract was made. So both parties had no expectation that this thing was going to happen that prevents the performance. The seller or lessor must notify the buyer or lessor as soon as possible of the delay or non-delivery. Duty of cooperation. If a party unreasonably refuses to cooperate, then the other party may suspend his or her performance without liability. An unreasonable, uncooperative buyer can be found to have breached the contract. If a party fails to cooperate, the other party may proceed to perform the contract in a reasonable manner. And so this is the duty of cooperation. So parties need to be in good faith with one another in a contract, and therefore they need to cooperate. Acceptance. The buyer, after receiving goods and having had a reasonable time to inspect, who doesn't reject the goods will be presumed to have accepted the goods. So he can't sit on his hands. Also, acceptance may be found if the buyer uses or resells the goods. However, there's an exception where in order to inspect the goods, it's necessary to test the goods. So there's an exception for testing. So a brief use is not an acceptance if it is necessary for the inspection of the goods. So you can imagine if you get a electrical equipment, you're going to want to at least run it enough to know that it's going to operate as it should. Otherwise, you can't really know how its performance. if after receiving the goods, the buyer must either accept or reject. So what this slide indicates is that after receiving the goods, the buyer must either accept or reject in a reasonable time. What's a reasonable time? It varies with the circumstances. Partial acceptance. A buyer who receives goods, some of which conform and others of which do not conform, may accept the conforming goods and reject the non-conforming goods. Okay, so you can reject. Now, what's the rule? Where the non-conforming goods were not reasonably discoverable prior to acceptance, then upon their discovery they may be revoked, in which case they would have to be substantially non-conforming. Revocation. Unlike rejection, allowing the buyer to revoke for any nonconformity which the buyer must invoke before acceptance. So I think in a previous slide we talked about the fact that you can reject goods for any nonconformity. So the contract goods that are being received must conform to the description in the contract. And if they don't, you can reject them for any reason that they fail to do so. So if there's something missing, you can reject it. The buyer must invoke before acceptance his rejection, and after the buyer's acceptance of goods, the buyer can no longer reject. So any nonconformity no longer applies. Instead, after the buyer's acceptance of goods, the buyer can still revoke his acceptance, as we mentioned before, but only if the nonconformity is substantial. So that's a substantial nonconformity rule for revocations. Okay, I'm going to compare two cases here. Jones orders a new car. When it comes in, he inspects it as best he can. That's all you're required to do. You're not a mechanic, and you're not expected to do something unreasonable like take apart the engine to make sure it's put together right. Even a mechanic wouldn't do that, and it's just too much trouble. But you inspect it as best you can, and he, on this occasion, discovers it is missing the spare. It's a donut, right? And because you don't get spare tires anymore, and he is told there's a shortage of these donuts. He therefore rejects the car. When he was sold the cars he looked at all had donut spares. And he says, I don't want to drive a car. This car I'm going to buy, I'm going to use it in my work. I'm a salesman, and part of my work takes me through the most dangerous streets in the city, the murder capital of the world at that time, Detroit. And if my car breaks down, I want to be able to quickly change my tire and not have to wait around in a bad part of town. And so he rejects it. Now, with that kind of reasoning, he might even be able to revoke. Is that a substantial nonconformance? Doesn't matter, because he's rejecting it. Any reason that it doesn't conform, for any reason it doesn't conform, he can reject. Let's take a little different case. Smalley orders a new car. It comes in. He doesn't inspect it. He signs for it, drives it home. A week later, he learns he has no spare tire. He wants to revoke. Can he? Well, here, he'd have to show that in his instance, it was actually substantial nonconformity. I mentioned that maybe Jones could claim substantial nonconformity, and it had to do with his use of the car. For his use of the car, it was important that the car have a spare tire in case he got stuck in a bad area. He needed to get out of there quickly. That may not be true of Smiley, so he may not be able, he can't reject because he already signed acceptance and he took the car home. He's had it for a week. These all indicate an acceptance. Now, sometimes you can take the car home, have it even longer periods of time, but if there were certain things wrong with it, it would be either substantially non-conforming, or you would be able arguably to reject it because your inspection didn't reveal, and your inspection was not going to reasonably reveal what was possibly wrong with it. And so in this case, he has to, if anything, he can't reject it. Can he revoke it? It depends upon whether or not he can show that is substantially non-conforming for him. So the substantiality pertains to that particular buyer. So it's a particular kind of thing for each individual buyer, depending on his circumstances. Okay, now we're going to look at a different case. A young man that I knew and represented had bought a car. He had traded in his old car, which was something that his parents had given him when he graduated, which was their old car. So they gave it to him when he graduated from high school. He wanted to get a new sporty car, so he traded in on a new sporty car, high powered car, high performance car, and was disappointed when it several times in the first 90 days broke down in traffic and basically wouldn't restart. The engine stalled out and then it wouldn't restart. He had to have it towed in. So he towed it in all these times to the dealership, which then, under the warranty, which he had a 90-day warranty given by them, tried to fix it, but apparently couldn't because it happened 3 times. And the 4th time it happened, he took it to a different dealership. They inspected it and they said, this car cannot be fixed. Why couldn't the car be fixed? Because apparently it had been at some time in a flood and its wiring had completely rusted out. And therefore the only way to fix the car would be to remove all the wiring in the car. In a modern car, there's a lot of wiring. The cost of doing that would be too high in terms of the labor involved of removing the wires and then replacing them. And so the car was actually totaled when he bought it. And I told him, I wasn't in town at the time, I told him to take the car back to the dealership, give them the key, leave the car with them, demand your old car back. You won't get it, they've already sold it probably. It's been almost 90 days. Your warranty's just about up. Demand that they return to you your money, and they'll have to return to you probably money for what you paid, and your down payment, and and the money that they credited you for the old car that you traded in. They won't want to do that. And I'll be coming to town next week, and I'll go in and talk to them. If they don't do it, I'll go in and talk to them, and I'll get them to do it, or we'll sue them. And if we sue them, we'll get 3 times the damages, because the state of the law in Ohio at that time was that way, where in a case like this, where they should give you the money back, they need to do that. Certainly a car that was non-conforming, that car was non-conforming when it was sold to them. It was sold and supposedly in good condition. That's why you have a warranty on it, right? And their warranty was a promise that if it wasn't in good condition, that they would fix it. And they weren't able to do that, and we know they couldn't do that, so this was substantial non-conformity. So arguably we could say 2 things. We could argue that he could reject it. On the argument would be that there was no way that he as an individual could have inspected that car and found out what was wrong with it. He's not a mechanic and he doesn't have the equipment to check the wiring in the car, and therefore we could argue rejection, but it's very easy to say we can definitely revoke the car because this is a substantial nonconformity. But going to court, I would argue both. I think I would win in any case on either theory. And I think if I went to court, I would then ask for the 3 times damages that the law requires when big parties like car dealerships mistreat small buyers like this young man who don't really have the capacity, who really want a car so they can get on with their life. And that's what exactly happened. Yes, I did have to go in and I talked to the manager, and the manager at first refused to give an inch, said that he wasn't going to buy back the car and that they still had the car and he should come down and pick it up. And I said, no, you're going to have to pay him, and you're going to pay 3 times if you don't. And I want you to talk to the owner and tell him that if he or you don't agree to take back this car, I will sue. And he's got a nice reputation. I saw him on the air advertising his car dealership and telling people what a wonderful car dealership he had and how he treated his customer rights. This would not look good if this got out, that this young man could not return this car under the fact that it had been previously in a flood. Your car, I know, were taking perhaps advantage. You perhaps didn't know that when you bought it from somebody who misled you as to the condition of the car. But nonetheless, once you sell a car and give a warranty, you are saying that in fact the car is in good condition and you're standing behind the car. And therefore, when it turns out it wasn't what you said it was, he has a right to revoke his acceptance, because this is a substantial impairment. The car has been totaled from the moment he bought it. It wasn't worth a dime when he bought it. So, and when I talked to the owner, we had a nice chat, and we both ended up smiling. He realized that what I was telling him was the truth. If I was really a rotten lawyer, I would have wanted to go to court, but I gave them every opportunity to settle the case before court. If I go to court, I get more money. But I thought my client wanted to have his money sooner rather than later. It would have taken some time, but I would have gotten more money. Anyway, can he reject or revoke the car? Yeah, I think he could have done either, actually. Okay. Anticipatory repudiation. Now, we talked about that before. If one of two parties clearly notifies the other of an intention to not perform or appears unable to perform. So that's the other possibility. I mean, if a person clearly comes out and says he's not going to do it, then that's an anticipatory repudiation. No two ways about it. You can't say, now, the party that does that, you know, after the other party has been given notice, the party who did indicate he wouldn't perform can retract his statement about not performing and decide to perform, and say, well, I'm going to perform. And so that's up until the party who actually has been given this insecurity of not knowing whether or not the other side will perform. If he hasn't acted, if he hasn't taken any action, what would be an action he might take? If he was a buyer, he might buy it from somewhere else, and you can't retract it if he bought it from somewhere else. Or if he's buying a service, if he bought the service from somebody else, you can't change that. He already contracted with somebody else, so he had a right to demand that you perform, and in the absence of your assurance that you will perform, he has a right to actually declare you in breach and take whatever steps he's allowed to, which would include the right to rescind this contract and enter into other contracts with other people and sue you for damages if he has damages. And he has to prove those damages. In a lot of cases, sometimes you don't have damages in these cases where somebody doesn't perform. Oftentimes, it's the performance that causes the damages, right? The performance is bad. And so, after giving notice, a party who has been subject to anticipatory repudiation can treat the contract as breach and rescind the contract. Upon notice of an intention to hold a party in breach, that party that may retract his repudiation given reasonable assurance of performance. And so you can retract the repudiation if you're given reasonable assurances of performance. So what are we talking about? Let me give you some examples. Examples of contracts where insecurity is inferred, causing a need for maybe anticipatory repudiation. A long-term contract involving installments where the buyer is substantially behind in payment. So he's received a number of goods. You're a factory and you've been sending goods to let's say you manufactured furniture, and you've been sending goods to this furniture store, and they haven't paid you for the last shipment yet. They didn't pay you for the last 2 shipments. You can suspend any further contracts. You can suspend this contract. You can send the next installment. You can say, I'm not going to send you anything else until you pay for what you received. You could actually go in there at some point and take back those goods that you have received that he hasn't paid for. To do that, you would need to declare him to be anticipatorily repudiating these installment contracts, these installments, and to be in breach of contract. And you would be able to clearly do that. Another example, a contract where the seller's production and delivery of contracted for goods to be delivered is in danger of not happening due to a threatened labor strike. In some instances, if you have entered into a contract to receive something, let's say you're entering into a contract to receive things that you need for your own production. So these are parts that are going into the whatever it is that you're producing. Maybe you're producing motorcycles or you're producing televisions, and you need to buy parts, and you're buying these parts from some factory that's workers are threatening to go on strike. And so they can't necessarily go on strike right away until the contract ends, but there's reportedly no way that the contract's going to end, or at least it looks as if they've reached impasse where the owners and the union have not agreed to a settlement of the contract's terms. So you can demand, if you're going to be waiting for if you anticipate that they may breach the contract, you might want to get out of the contract and contract with somebody else. So to do that, you need to assert that you are being made insecure and that you want to enter into a contract with other people, and therefore you're repudiating the contract, you're declaring them in breach unless they give you assurances of performance. So what assurance can they give you that they're going to settle this contract? And that may be a hard question for them to do. It's certainly something they wouldn't want to be publicly saying that they're going to agree to the union's terms. I think is about what they'd have to say, which is probably not what they want to do. And they may not. So that's just an example of where insecurity might arise. These are cases where the insecurity is inferred by what's happening. That is, the party isn't making his payments. His behavior is he's not making his payments. In the other case, the party that you're dealing with is not able, not willing perhaps, to settle with the labor union in order to get the strike behind him and resume production and shipments. And so sometimes it's inferred by the actions of the party in the situation as to how it puts the party who wants to claim breach, what kind of situation it put him in. We call that insecurity. He's been made insecure by the behaviors or by the situation that the other party finds himself in, and therefore wants to declare breach so he can get out of the contract and move on, perhaps to a different contract. Well, that's it for tonight.